Right from the start, this case isn't about routine procedure. It's about control. That no confession, no visitation claim flips the entire tone. Now, the question isn't just safety, it's whether access to the child is being quietly conditioned on someone admitting guilt. That's a dangerous gray zone. The system doesn't openly say it, but the pressure is there. Then the medical update steps in and strengthens the court's caution. Serious conditions, ongoing monitoring, developmental concerns. This isn't a low-risk situation, so even without pointing fingers, the environment becomes restrictive by default.
Melinda Powell for the Department St. Francis Permanency Specialist. Today is Shelby Brady, and Todd Walker is also present and will be handling part of the hearing.
Anthony Stevens for the mother. We're present and ready.
Bill
Your Honor,
Ham
I'm Tate Eldridge. I represent Isaiah Leal. We're both present and ready.
Bill Hamker on behalf of the grandparents, Mr. and Mrs. Ortega, we're present and ready.
Stacy Zabala on behalf of the child.
All right, thank you. Okay. Then Ms. Brady, if you'll unmute, raise your right hand for me. You solemnly swear to tell us the truth today.
Yes, I do.
All right, I'm gonna let you go ahead and just tell us your update, and then we'll see who's got some questions.
Okay. Arbor is doing good in her placement. She's 6 months old now. She was diagnosed with hip dysplasia, and so she does have to wear a hip brace for 6 months for 23 hours a day for those 6 months. So that, but she's adjusted well to it. Now it's kind of just part of her. She does continue to meet with her physical and developmental specialist, and they work with the daycare and the placement to help her continue to meet as much milestones as she can. Due to her hip brace, they're not working on sitting up, but they are working on her pushing herself up on her arms. And she's continuing to increase her time. And last time, whenever I met with them, they said she was up to 23 seconds. She hasn't had any more seizures still at this time, so she's doing well with that and her medication for that. She's eating well, drinking well, growing appropriately. The only concerns with her growth is the pediatrician noted that her head circumference was like a little bit smaller in proportion to her body growth. And so they wanted the placement to mention that to the neurologist next time. It's just so that they can make sure that her head is growing appropriately for her brain and her development with that, so that there's no complications with her brain being squished. I think that's mostly it for her. She is doing good given everything. She's continuing to make all of her appointments and things like that. Placement's doing a great job with her. For parents, they are meeting with me and talking with me. For Ashley, she's completed her parenting, her psychosocial, participating in counseling, and WAVE is scheduled to start now, or she's just started it. Her rational behavior therapy is completed. Her anger control training, I was waiting on notes from the therapist to determine if that was being covered in therapy or not. I just received some notes, but I don't have access to them, so I'm still going to be looking over that to determine that. Her drug screens, a UA and a hair follicle on October 31st, and then the UA on November 26th and January 29th were all negative. She's let me come to her house for announced visits. Her house appears to be appropriate, clean. She's showed proof of her reliable transportation and proof of employment. For Isaiah, he has completed his psychosocial. He's scheduled his next counseling session, and he's scheduled to start BIP. There was issues like with the provider with getting BIP and WAVE scheduled for them, so their kind of delay in starting those services aren't their fault. He has completed his rational behavior. No, he hasn't. Sorry. His drug screens on October 31st was a UA and hair follicle, and then a UA on November 26th, and those were negative as well. his housing. I have not actually been to his house, but he did come to the office to meet with me. And then our schedules were conflicting this past month, so we just met on the phone. And then he does have his transportation and stable employment. With his job, he travels out of town a lot right now. So that's what our schedules conflicting has been. But he has been compliant in talking to me and giving me updates as I ask for them and try to be in communication with him. And he's in communication with me for that. I did talk to the parents about my concerns about like kind of like accountability and the circumstances that led to removal and the incidents that could have happened or did happen. And just knowing how behavior has changed if we can't fully take accountability for the circumstances that led to removal and be in the process of being able to reunify, and how that will continue to be a concern.
Okay. All right, then Ms. Stevens, do you have any questions for Ms. Lucero?
Yes, thank you. Ms. Lucero, regarding accountability, you told my client that until someone confesses, nobody gets to see the child, correct? Hello?
Oh, I'm sorry. Y'all said questions for Miss Lucero. That is for me, correct?
Yes, I'm sorry.
Okay. No, sorry. I just was confused a little bit. That's my fault. So I said that until the medical team determines otherwise or gives approval for otherwise. That
Everything objection to everything after I said that as non-responsive.
Okay, Ms. Brady, let's let her ask her question again and just listen, just answer what she's asking you.
Okay.
Ms. Stevens, go ahead.
You told my client that until someone confesses, she will not get to see the child, correct?
No.
Objection asked and answered.
On paper, both parents are doing everything right. Clean drug tests, completed programs, stable living conditions. It checks all the boxes. But then the caseworker introduces accountability, and that changes everything.
All right, she's answered it now. So, all right, another question?
Have you contacted the DA's
Ms.
office
Stevens,
to find out the status of the case?
you're
Are you
cutting
there?
out. Ms. Stevens, you're cutting out. If you'll ask your question again.
All right. And I'm pulling over now that I have signal. Have you contacted the DA's office to find out the status of the case?
I have.
Okay. And when did you contact them?
I last contacted them. I can't remember the exact date, but it was a couple weeks ago now.
Okay. And did they tell you that they have declined the case as to my client?
Objection, Your
Your
Honor.
Honor, that object, that would be hearsay.
She can answer whether or not that's what they told her, because that's what they told me.
Well, it's
Yeah, that's a
pure
leading question.
it's
Objection
pure-
leading.
All right, hang
I-
on, everybody.
I can lead on cross-examination.
Judge, nobody's even,
It's not late. Hang on. It isn't leading. It's pure hearsay. Okay. So the objection is to hearsay is sustained. All right. Another question?
Is there any other services that my client hasn't started or hasn't worked yet?
The anger control training would be the only thing that I'm waiting for the notes to determine. I believe that she's completed the TPC assessment. I just haven't found the record for it yet, so I was waiting to get that.
Okay, so the anger management, there's no referral for that just yet, correct?
It's part of her family plan. Are you asking like that I've sent?
Yes. She doesn't have a referral to go just yet, right?
I guess not.
Okay. Pass the witness.
All right, Mr. Eldridge.
Miss Brady, I only have a couple of questions here. So just to make sure the judge understands, there was a mix up in the communication. Isaiah has been attempting to get his services scheduled, but there was a conflict. It wasn't his fault that he hasn't completed these services. He's been reaching out for weeks and weeks, from what I understand. Is that correct?
As far as for BIP, yes.
Okay. And he's been reaching out for the parenting classes as well, is the way I understand it.
Yes.
He hasn't been getting return calls, or he hasn't been getting anybody to text him back until just yesterday. Is that right?
Correct.
Okay.
He was,
So it's not his fault.
and I
the
was
services haven't-
correct. And I was
Go ahead.
receiving text messages from him as well, that he was trying to get in contact with them. And I was following up myself and have an email thread of communication with Family Support Services, trying to get that set up.
Okay. So now we're all back on track and he can get these services scheduled and completed. Is that right?
Yes.
And Isaiah is the non-offending parent in this case. Is that right?
I don't know that non-offending is the right word.
Okay. That's all I have, Your Honor. I'll pass the witness.
All right, Mr. Hamker?
Yes, Miss Brady, I think I just have one question. To your knowledge, regarding Arbor Lynn, is the investigation regarding the perpetrator still ongoing?
To my knowledge, yes.
Right. No further questions, Your Honor.
All right. Ms. Zavala?
I have no questions at this time.
Okay. Ms. Powell or Mr. Walker, any questions for your worker, for Ms. Brady?
Not for the worker, Judge.
No, Your Honor.
All right. Okay, then does the department have any other witnesses that are on the call today?
No.
All right, then, Ms. Stevens. I don't know whether you want to call your client or you got any other witnesses you wish to call today? Okay, you're muted, so if you're talking to us, we can't hear you.
I'm sorry, Your Honor. I'm not calling any witnesses. I just have argument to make, so I'll save that till the end.
Okay.
Unless you want
Are
me
there
to
any
make argument now.
Are there any requests involved in that? Because if so, I'd just soon hear it right
Yes.
now.
Yes, Your Honor.
Okay, go right ahead.
Thank you, Your Honor. We are asking for supervised visitation to begin based on the fact that the law states that reunification is always the primary goal. In her report, the caseworker said that she told them they had to take accountability to make reunification possible, but that's not in the law. The fact is, my client has worked every service that she's got a referral for, or at least started every service. She doesn't have a referral for anger management yet because the caseworker's waiting to see if that's covered in counseling or if that needs to be separate, I believe was her testimony. So my client is more than willing to do whatever referrals come next, but she has started every single thing. There's no reason to not start the supervised visits, but without supervised visits, we'll never be able to escalate visits if they go well. We can't work towards reunification. And in that way, without supervised visits, CPS is trying to hamstring the court to make the only option termination. Thank you.
Okay. All right, Mr.
Your Honor.
Eldridge?
Your Honor, this is
Your
Mr.
Honor, okay.
Okay, hang on. Hold on. All right. Yes, Mr. Hamker?
Yes, Your Honor, with respect to the opportunity to call witnesses, based upon the request of Ms. Stevens, I would like to have the opportunity to call the grandmother, Jerry Lynn Ortega.
All right, when it's your turn, you can certainly do that.
Thank you.
Mr. Eldridge?
The father's defense tries to shift the narrative from suspicion to cooperation. Delays in services? Not his fault. Communication breakdown? Not his fault. It's a clean attempt to reposition him as responsible and proactive.
So, Your Honor, kind of the same. First of all, I want to point out that Mr. Leal has started all the services that he's been able to. He's had trouble with communication with the department, and so he hasn't started and completed some, but he's been compliant. He's the non-offending. We're kind of pushing for the same thing. He's the non-offending parent here. His child is placed 2 hours away with the mother's parents, and so he's had FaceTime visits is all he's getting. We would like the court to consider placement with him as the non-offending parent. And if not, some sort of escalation of visitation so he can see the child more often. He's an electrician. He does travel, does commercial electrical work, but he's made arrangements from this point forward. He's in Virginia right now. He'll be home in about 3 or 4 days. From this point forward, he's going to work only locally. And his employer has freed up his schedule, so he'll be able to care for the child and at least spend more time with the child. And so we would like to escalate visitation as well. Similar to what the mother was asking.
Well, Mr. Eldridge, let me ask you, keep referring to him as non-offending, but he was living in the home at the time of the removal, correct?
Right, but the injuries were caused in the mother's possession.
Well, I mean, I'm not sure that anybody knows that 100%. That's the problem. Therein lies the problem in all these kinds of cases.
And these, okay.
So,
and if you have a problem with that, we would just like to escalate the visitation then. I mean, he hasn't been proven guilty of anything, just like the mother. At least supervised visitation will be appropriate, I believe, if you deem necessary or applicable.
So let me just ask Ms. Powell, I mean, have criminal charges been filed against either parent?
No, Judge.
All right. So we don't have a bond problem or bond issues that impede what we do, correct?
That's correct.
Okay. All right, then. Okay, Mr. Hamker.
Yes, Your Honor. Due to the questions and testimony, the first person I'd call is Mr. Leal.
The father?
Isaiah, yes.
Okay, Mr. Leal, you'll unmute, please. All right, sir, raise your right hand for me. You solemnly swear that you will tell me the truth today?
Yes, ma'am.
All right. Mr. Hamker, be mindful of Fifth Amendment.
Mr. Leal, in the last 5 years, how many criminal charges have you had filed against you?
In the past 5 years, one. It's
Seems like you're having a hard time thinking about that. How many are pending against you currently?
one.
How many have you recently disposed of?
They're pending.
That are pending? I guess my question is, you have some anger management problems, don't you?
No, sir.
Objection leading.
Or has
Told
there
him
been
it's a direct
an order
examination.
issued to stay away from Miss Lucero?
Hang on a minute, just a minute. I'm going to sustain Mr. Eldridge's objection. Mr. Leal, I'm already really far behind. I'm going to cut to the chase. How many criminal charges have you had in the last 5 years, whether they're resolved or unresolved? How many times have you been charged in the last 5 years?
Charged, like I guess it's one case, but there's multiple charges with that case. So that's why I said one. But it was like I didn't know how to answer it clearly.
What were you charged with?
It's a domestic violence case with Ashley.
Okay. So domestic violence or assault on a family member?
Assault on a family member, yes, ma'am, and to a pregnant woman.
Okay. What else was in that charge? What else were you charged with at that time?
I believe it's those, and then it's a repeated like offense. So it's like multiple with them.
Okay,
So it's like they repeat pretty much.
right. So you've had prior assaults against a family member.
I believe what he
Uh,
stated, Your Honor, he was
Yes,
charged. The charges are pending, if I understood correctly. He's not, my understanding, not been convicted. Is that right, Isaiah?
Okay,
yes,
all right.
yes.
Mr. Hamker, does that help?
That answers my question. I just have one other regarding Mr. Leal. Was Ashley Lucero supposed to be living in your home on South Washington on the day the child sustained this injury? Was
Yeah,
there order in place?
I'm gonna object, Your Honor, and due to the Fifth Amendment implications of that, I advise my client not to answer.
All right, Mr. Leal, your attorney's admonishing you not to answer the question based on your privilege against self-incrimination. Is it your desire to invoke your Fifth Amendment privilege?
The grandmother quietly becomes the most credible voice in the room. She's not defensive, not aggressive, just steady. She confirms the child is thriving, which locks in the current placement as safe and stable. But then she adds something critical. Both parents still need work.
Yes, ma'am.
Okay, Mr. Hamker, any further questions?
No further questions, Your Honor. I would call Jerry Lynn Ortega.
Okay, Ms. Ortega, you'll unmute.
Can you hear
Raise
me?
your right hand. You solemnly swear to tell the truth this morning.
Yes, ma'am.
Go right ahead.
Ms. Ortega, you're the grandmother of Arbor Lynn, is that correct?
Yes, sir.
And this is your husband seated next to you?
Yes, sir.
Okay. Uh, are you all able to take care of her?
Yes, sir.
Okay. I understand she's just recently had her second brain surgery. Is that correct?
Yes, sir. On January 22nd.
Okay. How's she doing?
She's doing really well. She's accomplishing all of her milestones, and she impresses everybody at every point we go to. They're just amazed at her strength and her drive. She's great.
Okay. You've heard your daughter's attorney request for supervised visitation. What type of visitation is your daughter receiving with the child at the current time?
Both parents currently get supervised virtual visitation, supervised by St. Francis.
Okay. Do you believe that supervised visitation, a change in the current visitation to supervised visitation would be in the best interest of the child or not?
Your
I do
Honor,
not.
I'm gonna object. I would call for a legal conclusion. That's the court's determination to make, not the grandmother's.
Well, let me change the question, Your Honor.
Are you withdrawing the question?
I'm just changing it, Your Honor.
Well, then I'll rule on his objection sustained.
Okay. Do you think it's good for the child to change the visitation structure at the current time?
Objection, Your Honor. That calls for legal conclusion. It's just rewording the same question.
Sustained.
If the visitation is changed, who do you think should supervise it?
Objection calls for speculation.
I'll overruled. I'll allow her to answer that. She can have an opinion on that. It's not a expert opinion.
I would like to be able to supervise the visitation if it is changed.
Okay. Do you have any concerns regarding your daughter at the current time?
I have concerns regarding both parents. I think that they both need to focus on completing their counseling and parenting classes, hopefully before any changes are made in visitation.
Okay. Do you believe that this was an accident that happened to this child, that she fell or something like that that caused these
Your
injuries?
Honor,
Objection
Your
calls
Honor,
for
that's
speculation.
complete. Yes, I have double that
Sustained.
interjection.
Sustained.
Okay.
Pure.
No further questions, Your Honor.
All right. Any further witnesses? Mr. Hamker.
No further witnesses, Your Honor.
All right, does the department have any questions for this witness?
I do not, Judge.
All right, Ms. Stevens?
No questions, Your Honor.
All right, Mr. Eldridge, any questions?
No, Your Honor.
Ms. Zavala, any questions?
Ms. Ortega, do you have concerns about in-person visitation?
Yes, ma'am, I do.
What are those concerns?
Right now, kind of like when she was injured, Arberlynn's too young to tell anybody what happened to her. And if something were to happen to her, she doesn't have her own voice where she could speak, ask for help, tell somebody something's gone on. She's 6 months old. She's still completely helpless and needs to just be able to trust that everybody's around her is safe. And at this time, we're able to make sure that that's the case.
No further questions.
I have one question now, Your Honor.
All right, go ahead.
Ma'am, based on the testimony you just gave, does that mean that you are worried that you cannot supervise adequately if there is supervised visitation?
I think objection, Your Honor, mischaracterization of the answer previously given.
She said she's worried the child wouldn't be safe during
Oh.
supervised visits.
Oh, overruled. I'm going to allow her to answer it.
Please re-ask. I'm sorry.
No problem. Ma'am, I don't think you meant to imply this, but I'm just trying to be clear. Do you believe, based on the testimony you just gave, that you cannot supervise properly if there's supervised visitation? Meaning, can you not keep the child safe if you're the supervisor for visitation?
I would absolutely do my best to keep her safe. It's hard to watch everybody's hands at all times, and there's no question that she was hurt very badly.
Objection not responsive after I can't watch everybody's hands at all times.
Sustain.
No more questions, Your Honor.
Sorry.
All right, anybody else have any questions for Ms. Ortega?
No, Your Honor.
Okay. Ms. Ortega, a big thank you from the court for taking good care of the child and seeing her through this medical journey. And
Yes.
I greatly appreciate what you're doing.
Absolutely. We love her.
All right, then, Ms. Zavala, any witnesses to call today?
No witnesses, Your Honor.
All right, do you have a recommendation to make today?
Your Honor, I'm extremely grateful to the Ortegas for placement. She has been doing incredibly well there. I do recommend that placement should absolutely continue.
The attorneys go aggressive again, pushing for visitation and even placement. They lean on the law. Reunification should be the goal. And they're not wrong. But the judge isn't operating on theory. She's operating on uncertainty. No one knows what actually happened to this child.
This is a scary case when we have such severe injuries for a child so young. I would recommend, although Ms. Ortega has offered to supervise, I would recommend that if in-person visitation is started, that Ms. Ortega be allowed to be present, but there also be someone from St. Francis there to supervise. I think that helps with documentation in terms of how those kinds of visits go. And I think it's important. But I do think for Arberlynn's continued well-being in terms of her feeling of security, that Ms. Ortega being present would be very important if those visits are started. I have concerns. I understand that some of those services may not have been started, not to the fault of the parents, but the whole issue here appears to be violence. And at this point, none of the service, although lots of services have been started, the services regarding the actual violence and anger have not been addressed at this time.
Ms. Valla, do you have a recommendation whether or not to start in-person visits or whether to leave them virtual?
You know, this is incredibly difficult. And I do believe that the law requires that at some point visitation be started. And I honestly do not know when the appropriate time to start that is. I'm really struggling with that decision. I do feel that Arbor Lynn could be kept safe as long as that remains supervised. And at some point, it is going to be time to start that. I just, without any kind of training for the parents on the underlying issues of anger and violence, I'm very hesitant to make that recommendation at this time.
Understand. All right, then. Today, I'm going to continue the department as temporary managing conservator, and I will continue the child's current placement. I do find a continuing danger to return the child home at this time to either parent. I do find parents are in compliance with their family plans of service at this time. I'm going to go ahead and allow them to have in-person supervised visits with the child. St. Francis and placement will be present during those visits. But that being said, I will just tell the parents, I fully expect you all to complete your services and with a great concentration on parenting of a child this age and, you know, in all required services that touch upon anger issues, violence, and all those things. So I'm not saying it's your fault that some of that's been a slow start, because you guys aren't the only ones that we have that problem with. So, but the minute you can get started on those, I do expect you to do it, and I expect you to make those appointments. I don't want to hear down at the next hearing. I don't want to hear that, oh, well, you started those and then you missed 5 in a row. Okay. These people will discharge you from those programs if you miss. And so you will really, really be behind if that happens. So just word to the wise, those appointments are going to be your top priority. All right.
Your Honor,
Yes.
Your Honor, may I make one request about those supervised visits? Can they be separate for each parent? My client does not want to be around her former abuser.
Yeah, I mean, they're not supposed to have any contact with
Objection,
each other.
argumentative. I object to the sidebar comments, Your Honor.
I'll sustain as to that. The bottom line is that at the time of this removal, and as far as I know, sitting here today, they're not supposed to have any contact. So obviously those visits need to be separated. If the no contact order isn't out there or has been lifted, they still need separate visits.
And I believe that there's a bond condition with the pending criminal cases anyway, so there shouldn't be that contact. I think there's that prohibits the visitation being together.
Yeah. Okay. All right, then, I'll see everybody back for our next review hearing, July 28th of 2026. That's a 9 o'clock docket. The final in this case is scheduled for September 29th, 2026. That's also on a 9 o'clock docket, just so everybody knows. Dismissal date, October 5th of 2026.
Your Honor, could I ask that those visits that are going to be taking place, that the child not have to be stressed by being hauled all the way down to Amarillo, that at least maybe the other people make the effort to maybe go to Canadian so those visits can be taking place?
I'm going to allow St. Francis to work out the logistics of that, Mr. Hamker. And it
Okay.
may be that everybody, you know, they may have to go there. Maybe there's a meeting point. Maybe sometimes they go there and sometimes placement comes here, but I'm going to allow St. Francis. They know these people's schedule. I don't know their schedules. I just can't make a ruling on that in a vacuum. So I'm going to kick that can to them to try to figure out the best way to schedule it.
Okay.
Obviously, taking into account the child's medical needs and health and everything. Okay, I'll see y'all back in July.
Your Honor, can I ask one more thing?
Yes, sir.
I had filed a motion, and I know there's not time for a hearing on it, but my clients are going to hire an expert and do a forensics assessment in this case. I know does not have to be a court order to do that, but we would ask the court to at least, we'd like you to know that, and we would like to have at least the cooperation of the other parties in this case who have documents that the expert that's going to be needed on this case, so that specialist can make that assessment, which is going to be provided to the court.
Okay. You know, I always love it when attorneys will cooperate with one another, but in absent of that, there's this thing called discovery.
The final ruling isn't a victory, it's a controlled experiment. The judge allows supervised in-person visits, but under strict conditions. Both placement and an agency must be present. That's not flexibility, that's surveillance. Every interaction is now being watched, documented, and evaluated. Then she raises the stakes, miss appointments, fall behind, and you're done. No second chances. This is where the case shifts from argument to performance. The parents aren't being judged on what they say anymore. They're being judged on what they do next. And separating the parents during visits? That's pure risk management. The court isn't convinced either one is safe enough without structure. So now everything moves forward, but only under a microscope.